Hello, law students and legal practitioners. Today, we will analyze the case of Bases Conversion and Development Authority versus DMCI Project Developers, Inc., GR number 93833, decided by the Supreme Court on September 28, 1995. Let's begin. Here are the legal doctrines of this case. An arbitration clause contained in a principal contract extends to subsequent contracts executed for the same purpose when such contracts are merely amendments, supplements, or implementations of the original agreement. A nominee, assignee, or beneficiary of a contract containing an arbitration clause may compel arbitration even if it is not a signatory to the principal contract, provided that the intent of the parties and the nature of the agreements show that such entity was contemplated to be bound. Arbitration agreements are liberally construed in favor of arbitration pursuant to the state policy embodied in Republic Act No. 876 and Republic Act No. 9285. Any doubt as to the scope or application of an arbitration clause must be resolved in favor of arbitration. A non-signatory corporation that knowingly accepts benefits arising from a contract containing an arbitration clause and whose existence and purpose are directly founded on such contract may be bound by, and compelled to comply with, the arbitration agreement. Here are the relevant facts of the case. Bases Conversion Development Authority, BCDA, Philippine National Railways, PNR, and several foreign corporations entered into a joint venture agreement, JVA, on June 10, 1995 for the construction, operation, and management of a railway system from Manila to Clark, with possible extensions. The JVA contained Article 16, Arbitration Clause, providing that disputes arising from the agreement shall be submitted to arbitration under Republic Act No. 876, with arbitral awards being final and binding. Pursuant to the JVA, BCDA incorporated North Luzon Railways Corporation, Northrail, to implement the project. On February 8, 1996, the JVA was amended to include DMCI, Inc., DMCI, and/or its nominee as a strategic partner. On the same date, the parties executed a Memorandum of Agreement, MOA, to raise 600 million pesos seed capital for Northrail, of which 300 million pesos was attributable to DMCI. DMCI later designated DMCI Project Developers, Inc., DMCI PDI, as its nominee in all agreements related to the project. DMCI PDI deposited 300 million pesos into Northrail's account as deposit for future subscription of shares. However, Northrail subsequently withdrew its application to increase its authorized capital stock, allegedly due to requirements tied to foreign funding. DMCI PDI demanded the return of its 300 million pesos deposit. BCDA and Northrail refused, claiming the amount was a capital contribution subject to business risk. DMCI PDI then demanded arbitration pursuant to the arbitration clause in the JVA. When BCDA and Northrail refused to arbitrate, DMCI PDI filed a petition to compel arbitration before the RTC of Makati. The RTC granted the petition, ruling that the arbitration clause covered all related agreements and bound the parties, including DMCI PDI and Northrail. BCDA and Northrail elevated the case to the Supreme Court. Here are the issues resolved by the Supreme Court. Issue 1. Whether DMCI Project Developers, Inc., a non-signatory, may compel BCDA and Northrail to submit to arbitration. Yes, DMCI PDI may compel arbitration. Republic Act No. 9285 declares a strong state policy favoring arbitration and party autonomy. Arbitration clauses are contracts and must be interpreted liberally to give effect to the party's intent. Jurisprudence recognizes that arbitration agreements may bind non-signatories such as nominees, assignees, or beneficiaries when their participation is clearly contemplated in the contract. Under contract law principles, a contract need not be contained in a single document. Several documents executed for the same purpose, referring to one another, and forming part of one transaction must be read together as a single contract. The JVA, the amended JVA, and the MOA were executed for the single purpose of implementing the railway project. The amended JVA expressly included DMCI and/or its nominee as a party. DMCI validly designated DMCI PDI as its nominee, and the agreements expressly allowed nomination. Thus, DMCI PDI stepped into DMCI's contractual position and acquired the right to invoke the arbitration clause. Issue 2. Whether the arbitration clause in the joint venture agreement extends to the amended JVA and the Memorandum of Agreement. Yes, the arbitration clause extends to all related agreements. An arbitration clause in a principal agreement extends to subsequent agreements that are amendments, supplements, or implementations of the original contract, especially when such agreements are executed by the same parties for the same objective. Courts adopt a construction that renders the arbitration clause effective rather than immutable, in line with the policy favoring arbitration. The amended JVA and MOA merely modified equity participation and funding mechanisms under the original JVA. They did not create a separate or independent contractual relationship. Hence, the arbitration clause in the JVA necessarily governs disputes arising from all agreements forming part of the same contractual framework. Issue 3. Whether Northrail, though not an original signatory, may be compelled to arbitrate. Yes, Northrail is bound by the arbitration agreement. Non-signatories may be bound by arbitration agreements when they knowingly accept benefits under the contract or when their existence and obligations arise directly from such contract. A third-party beneficiary who accepts benefits under a contract may also be compelled to comply with its obligations. Northrail was created pursuant to the JVA, derived its authority and capitalization from the agreements, and accepted DMCI's funds. Its rights, obligations, and existence are inseparable from the JVA and related agreements. Having accepted benefits, Northrail cannot repudiate the arbitration clause embedded in the same contractual framework. Thank you for listening and happy learning. Please don't forget to subscribe to the Legal Shepherd PH YouTube channel and click the notification bell to stay updated on newly uploaded cases and jurisprudence. See you again for our next case discussions.